Thank you. Our second presenter this morning is Richard Edmunds, and Richard's topic is Barro and litigation funding orders. Richard's also a senior barrister. He was admitted in 1979 and signed the bar roll in 1988. Richard has a busy civil practice. There's no criminal element to it. His practice embraces family and de facto law, wills and estate matters, and general civil litigation. As a part of his practice, or as a part of the specialty of his practice, Richard is Secretary of the Property and Probate Section of the Commercial Bar Association. As I said, Richard's topic is Barro and litigation funding orders, and please welcome Richard Edmunds.
Thank you, Michael, and good morning. Topic is Barro and litigation funding orders, a topic that's probably dear to the heart of all practitioners, particularly when you're involved in a case that seems to go on forever and you're acting for the unfunded and impecunious litigant who's trying to get a reasonable property settlement out of a party who has got quite often sole control of a whole range of assets, or in some cases asserts that he's got no interest and no control in the assets, and sometimes argues that he's got no assets at all, yet somehow manages to live a life of Riley in the meantime with the wife struggling. The term Barro order, everyone's probably heard it. It's been around for years. When you try and track back where it comes from, a case of Barro and Barro, the only direct reference I could get was actually a full court hearing in the matter of Barro and Barro, which referred to the initial decision of Justice Strauss in a 2000 decision. So that was about 5 years after the implementation of the Family Law Act. And in that case, Justice Strauss ordered, in effect, that the husband provide a sum of $12,500 by way of security of costs for the wife's legal costs of investigating the husband's financial affairs. And those monies were to be paid to the wife's solicitors. Doesn't seem a lot these days, $12,500. I'm trying to remember what we all charged back in 1980. In 2000. Actually, I beg your pardon, if it was in 2000, the Family Law Act obviously had been going for more than 5 years. The decision relating to Barro order funds it's my typing. One of the problems of putting these papers together and then not checking dates properly is I've got here 2000 for the decision on Barro. It was in fact a 1983 decision of the full court relating to a 1980 decision of Justice Strauss. So it was some 5 years after the implementation of the Act. Ended up in the full court because third-party companies sought to intervene in the proceeding. And part of the order that the full court made was that the wife's costs of being involved in that argument relating to the intervention and the appeal proceedings be paid out of that fund. So $12,500 probably started disappearing fairly quickly. Most practitioners are probably familiar with the term Barro just being used in a generic sense in the courts, just hearing applications to the court for a Barro order for money to fund a case. More frequently now, the courts are asking practitioners to identify what specific head of power that application is made under, whether it's sought by way of a security for costs order under Section 117 of the Act, whether it's a partial property settlement under Section 80, subsection 1, subsection 8, and consequently Section 79. In relation to Section 117 for the security for costs, court has got power to order security for costs whether by way of interlocutory order or otherwise. And it's a discretionary power. And you have to look at the factors in section 117 to capital A of the Act to work out what the court has to have regard to. And they range quickly from the financial circumstances of the parties, whether any party in the proceedings in receipt of assistance by way of legal aid and the terms of any grant, conduct of the party in the proceedings, and this is particularly relevant, conduct in relation to matters which include pleadings, particulars, discovery and inspection, and that's one of the major factors in these cases, that where conduct of a party in withholding proper discovery can often result in a court determining that that conduct is such that the other party is never going to get a true picture of the financial circumstances unless they're properly funded. Other factors, whether a party has failed to comply with previous orders of a court in the proceeding, whether any party's been wholly successful or unsuccessful in the proceedings, whether there's an offer made in writing to the other party to settle proceedings and terms of that offer, and any other such matters the court considers relevant. Most practitioners who have applied for Barro orders are probably, well, would be familiar with the process where it's necessary to put before the court material identifying why you're seeking that order, what sort of costs you're seeking to have paid in relation to costs incurred to date, and future anticipated costs of the proceeding. If you've got a costs agreement, you should exhibit that costs agreement so the court knows how you're charging. You should also identify whether you're charging according to scale. You should be able to identify assets that are available to the parties against which some costs or funding order might be made, so that you can attach some property to make that payment, whether it's by way of a payment from a fund, whether it's by way of mortgaging or selling a property. Other matters include identifying the costs of anticipated expenses for experts, whether they be valuers, forensic accountants, and identifying also, as I've mentioned before, discovery issues. If you anticipate that there'll be lengthy, costly subpoena exercises involved. Quite often, you find Barro applications are linked in with applications for spousal maintenance, applications for partial property settlement. And a way of dealing with a lot of the orders without actually specifying particularly what the nature of the payment is with courts making orders that characterise the final payment or the payment as being left to the trial judge. And that process was adopted and applied after a number of court decisions where that process was adopted. But many of the applications, I shouldn't say many, but a number of the applications, the judges will actually particularise at the time of the making of the order whether they're making it by way of partial property settlement or by way of litigation funding order. A number of cases I'll mention where the full court has looked at questions of funding orders and partial property settlement orders and the changes in relation to those approaches. After Barro, there was a full court decision in Piggott in 1990, and that was looking at what a court should look at in relation to making an order under section 80 of the Act. And it identified 5 areas: the complexity of the respondent's financial affairs, the need for expert investigation of those affairs, a position of financial strength on the part of a respondent, a capacity on the part of the respondent to meet his own costs, and an inability on the part of an applicant to meet her costs. In 1996, full court in Joski's case looked at Section 80 and Section 79 and held that where property proceedings under Section 79 are pending, the court may, under the provisions of Section 81H and independently of the power under Section 117(2), require a party who controls most of the assets to provide the other party funds to conduct his or her case, with the provision of such funds being then a matter to be taken into account in the final settlement of property between the parties. So you there have the full court setting the scene for the orders that most practitioners are familiar with, where you have the identification or characterisation of the payment being left to a trial judge. In a case, Bing's case, it's rather interesting to see the title to some of these cases, because after a certain point in time the process in the courts was to give them a pseudonym. And when you had some passing involvement in some of these cases and then you see them, you get the judgment, and usually at the bottom they don't put in anything other than pseudonym to be provided. And then you read them in the reports and you see an entirely different name and you think, I know that case. And Bing was one of those cases that had so many iterations, and so many of these cases that seem to get reported with matters relating to interim property settlements or litigation funding orders seem to come back time and time and time again. And in, I think, one case, Strawn's case, which was recently decided, if you just look at the case, if you're lucky enough to find the specific reference to it for the argument or the issue that you're looking for, you go to the Ostley site and you look at the list, and I think in Strawn's case, I think there's about 10 Strawn decisions in the Ostley list, Strawn 1 through to 10, and they seem to have got tired of putting numbers on them, so they then put in brackets Strawn interim property settlement, Strawn disqualification hearing, and on it goes. And they're examples of cases where well-funded litigants tend to drag parties back to court time and time and time again. One might cynically say, in the hope that under the burden of such constant litigation, they'll run out of funds. Bing was a case where there were many applications and proceedings before courts. And in 2007, a husband who had a costs order made against him earlier had applied to have leave to set that costs order aside. Costs order was for some $200,000, and wife also got an order for $30,000 for interim spousal maintenance. It wasn't a small case. Husband asserted his assets were about close to $8.5 million, of which he was fully in control of, and asserted he couldn't find the $200,000 sought by the wife. Now, Justice Mushin at first instance thought that was a little bit unbelievable. Didn't think that husband would have too much trouble eventually being able to find that money. And he made an order that the husband pay the $200 plus the spousal maintenance sort of $30. In making the order, he expressed a concern that a practice had developed of making orders without specifying the relevant power. And ruled that, in his view, if it was necessary to make a specification in respect of the $200,000, he would do so that it was provided by way of security for costs under Section 117. He then went on to say, but in any event, it's appropriate that I provide liberty to the parties to argue the ultimate disposition of these monies at final trial, and for the judge to make a decision then. The leave argument was based upon two arguments. One, that there was an error in principle in making an order for payment of $200,000 for security of costs when there was no evidence of a fund readily available to pay it, and also that the matters under section 117(2) of the Act hadn't been properly addressed. Full Court didn't have any trouble refusing leave and said, notwithstanding the description of $200,000 was provided by way of security for costs, the reservation by the trial judge to recategorise the payment militates against granting leave to appeal. And then went on to say, the duty judge is often in an impossible position in cases of this nature. The very issues that need to be fully investigated, namely the extent of the asset pool and the financial resources of the parties, cannot adequately be investigated without the provision of appropriate funds. The mere question that there are no immediately available funds to provide to the applicant to enable him or her to continue on with the proceedings cannot simply be accepted at face value. If it's apparent that one party controls a vast pool of assets, irrespective of whether those assets are readily capable of liquidation, then the court has a broad discretion to enable an order to be made for provision of funds by the holder of those assets to enable the other party to continue with the litigation. And the court there adopted the previously cited passages I mentioned in Joski's case. In relation to another way of getting money for your client, if it's not by way of a costs order, cases have made provision for interim property settlements, and out of those interim property settlements, your client can fund their case. The earliest case relating to interim property settlements from the full court was Harris and Harris in 1993, and there was a three-step approach established in that case, and the rules were set as follows. The exercise of power should be confined to cases where the circumstances presented at that time are compelling. Now, I'll come back to that first point later because that's a significant point, because that set a thread for how parties presented their cases over the years. Second was to exercise the power within the parameters of section 79 and the material available at the time. And the third was the court must be satisfied that the remaining property will be adequate to meet the legitimate expectations of both parties at the final hearing, or that the order which is contemplated is capable of being reversed or adjusted if it's subsequently considered necessary to do so. Now, it was only recently, in 2009, in one of those many Strawn cases, and it came under the heading of Strawn and Strawn interim property orders, where the full court reformulated that three-step approach that had been applied for years in Harris and Harris and got rid of the first requirement, that the power should be confined to cases where circumstances presented are compelling. The majority in Strawn in that decision noted that there were two stages of a hearing of such application under section 81H, and that in exercising those powers recognised that under section 79, property settlement orders, it should ordinarily only be exercised once, but circumstances may arise before a final hearing where that power is to be exercised. So your first step is to resolve whether the exercise of power before a final hearing is to be used, and then the second step is to exercise the power. Full court did endorse in what was said in Harris and Harris that section 80 is intended to be a wide enabling provision, and there's no justification for imposing limitations on its normal and ordinary meaning and operation when applied to section 79, even though that same court in Harris had effectively put a limit on it by limiting it to cases that were compelling. Court then went on to effectively say that if you're going to make an interim property settlement order, it must be appropriate to do so in the circumstances of the case and so as to achieve a just and equitable result. And noted that in making an interim property settlement, the overarching consideration is the interest of justice. It's not necessary to establish compelling circumstances. All that's required in the circumstances is that it's appropriate to exercise that power. That the court has a wide and unfettered discretion, and regard should be had to the fact that the usual order pursuant to Section 79 is a once and for all order at a final hearing. And then went on to note that once you decide to make that an order for an interim property settlement, you then look at the matters in Section 79.4 and Section 79.2. In Strawn also, so the full court in Strawn also noted that the legislation does not prescribe any preconditions, and they don't seek to exhaustively prescribe any of those conditions. And concluded, we also emphasise, in order to establish an appropriate case for an interim property settlement order, more is required than the mere fact that on a final hearing, the applicant would receive the property being sought, or an amount of funds in excess of the amount being sought from the other party. So you've got this removal of the compelling circumstances for interim property settlements, but you still have to establish that it's just and equitable and reasonable, as well as the likelihood that you're going to get or claw back what's been paid in the event that there's an interim distribution. Another area where parties may be able to get money to fund their case in circumstances where you're not going to get an interim property settlement order because on the facts that appear before the case at the time that it goes to trial, the party in control of the assets or whom it is asserted is in control of the assets pops his hand up and says, I've got nothing. I don't control anything. I'm not a director of any of the companies that the other party is saying comprise or have an interest in the asset pool. Those companies, they're just trustees of a trust. And it may come as a surprise to hear that husband or wife, usually a husband, say, and I've got no beneficial interest in any of these trusts. And it's going to be a very costly exercise to pursue the inquiry to see whether or not he's telling the truth, whether or not in some way he or she has divested themselves of some interest in assets that you may be seeking to set aside under Section 106B. How do you get an order if there's no property against which a litigation funding order can be made? There's a number of cases that adopt an approach of what's called a dollar-for-dollar order. And they apply in cases where the court is satisfied that one party who asserts that they've got no real financial interest at all, surprisingly manages to have their legal costs paid by some third party. Not surprisingly, quite often, one of these trusts that might be one that he says he's got no beneficial interest in, or a company that he says he doesn't control. The most recent exposition of an approach in relation to dollar for dollar is a decision of Justice Cronin in Ifostru and Ifostru. It's a 2011 decision delivered on the 18th of January this year. And the wife in that case made a sort of a broad claim for litigation funding both under section 117 and also under section 80 subsection 1H. And in that case the husband said he didn't have any beneficial interest in any entities, didn't have any property. He was merely a consultant and chief executive officer of certain entities, but didn't have any controlling interest. Court was satisfied that on the evidence before it, there was no property that was currently identifiable which it could make an order for an interim property settlement, and no readily available fund against which it could make an order that the husband would pay or provide monies to fund the wife's claim to investigate his financial affairs. The matrimonial home in that case had little or no equity, having had borrowings against it to ironically drawn down by the husband, and the equity had reduced, but husband had then had those monies paid to one of the entities. The husband had a number of motor vehicles, very expensive motor vehicles, but none of them were his, all owned by or leased by companies. He said that he didn't have any plant equipment, no financial resources, only had an income of $1,500 a week, and his expenses were about $1,035 a week. There were in the background proceedings relating to section 106B to set aside a whole series of transactions involving the husband and his sons, who surprisingly ended up as directors and shareholders of most of the entities. Justice Cronin did find, however, that there were circumstances where he could make an order under section 117 of the Act, because in that case the wife had actually subpoenaed the husband's solicitor's trust account records, and they showed that over a period from February 2010 to November 2010, husband had paid to his solicitors legal costs of $345,000 odd. And when I say the husband had paid, actually, the husband himself didn't pay those monies because he didn't have them. They were paid on his behalf. And Justice Cronin noted that husband denied not only an interest in the substantive assets, but more importantly, does not have a capital entitlement owed to him by the company in some form of loan account. So he went on to note, one would therefore wonder why a company that owed the husband nothing might be significantly generous to him. No explanation was given as to what these sums were for. Went on to say, presumably a company employee, whether as a consultant or otherwise, would not require legal expenses that significant to have his employer pay unless he was involved in litigation. If these payments were as a result of the largesse of the husband's employer or any trustee of a trust, there is every preliminary reason for me to consider them a financial resource of the husband. His Honour noted that in that case there was at least a prima facie case that the wife may have an entitlement under section 79 that justified an order for costs because of the complexity of the problems and the different capacities of parties to fund the litigation. And observed that for a person who has no control of limited assets, the payments on behalf of the husband of these legal fees are extraordinary, if they are concerned even in part with the family law proceedings. So he made an order called a dollar for dollar order, where any money that was paid to the husband's solicitors for the husband's legal costs, the husband was required to pay the same amount to the wife's solicitors. The further condition attached to that order was that if the husband didn't pay that money within 7 days, and the husband's solicitors weren't to draw the money that he had paid into their account within that time, then they were to pay 50% of what they had received to the wife's solicitors. So it's a very interesting case, very useful. It's not a term or an application that practitioners probably commonly hear in Victoria. Cronin J did refer to a decision of Justice O'Reilly in a fascinating titled case of G&T. So you wonder just who sits in the back rooms writing up the names of these cases. And she referred to an earlier decision of hers. And in that case, she made a dollar-for-dollar order in a similar situation where a husband claimed to have no real interest in assets other than to say that his legal costs were paid from time to time when there was cash available from a capital account of a partnership. And again, in that case, the Judge O'Reilly found that there was a financial resource so she could make a payment, and made the observation that in that case he should pay an equal amount to the wife's solicitor to maintain a level playing field. And Justice Cronin, when he was delivering his decision in January, observed that cases involving complex commercial family disputes are often not a level playing field. It is important that, if possible, an attempt is made to level that playing field. The best way to do so is to ensure, whenever a payment made to the husband's lawyers for preparation of material, an equal amount paid to the wife's practitioners. And he was satisfied the wife had no other source of funds, and without that assistance there will not be a level playing field. Now, His Honour wasn't saying in making that decision that the principle in making a costs order is to ensure that there's a level playing field. He looked at the provisions of section 117 and was satisfied that it was appropriate that there ought to be a costs order made. And one can anticipate one of the, surprisingly, for practitioners who see these sort of cases, probably not surprising really, notices of appeal have been lodged by the well-funded but impecunious husband, asserting that, amongst other things, that a wrong approach was taken in the assessment of making that dollar-for-dollar order. Now, as Michael mentioned at the commencement of today's session, papers will be emailed to all attendees. The paper that I've put together also comprises a list of various cases where applications for litigation funding orders have succeeded, cases where some of these applications succeeded in part, and cases where there were complete failures. It's probably, having regard to the time, not much point running through those that succeeded, other than to note that the court was satisfied that there were funds that were available or assets that were available against which orders could be made. Some cases, the argument just boiled down to what was the security or where was the fund going to come from. And in cases where husband would be saying, further encumber the home, leave my very expensive property, farming property or whatever it is alone, and it was clear that the wife would get at least the modest house that she was in, the obvious answer was to encumber or provide a fund from that which was not going to ultimately have to be discharged anyway. In some cases where they part succeeded, the cases I've referred to identify where parties have asked for too much and only got what the court considered was reasonable to be necessary to prosecute your case. And bear in mind that a number of the cases also recognise that you don't have to make one, you can make a number of litigation funding order applications as the case progresses, particularly if you only need a certain amount to commence proceedings and investigations. You then find that there's a lot more complex financial discovery and inspection and forensic reports required. And in some cases, parties have gone back 2, 3, 4 times. Those that failed, I just want to make this observation and simply refer you to the cases that are referred to in the paper. Those that failed often failed because practitioners didn't put the right material before the court, didn't put before the court details of what the costs agreements were or the costs that were being charged, whether it was by agreement or scale. They didn't identify, in some cases, whether they were going to charge the wife now and wouldn't proceed with the action if they weren't paid, or whether or not they might only wait till the end of the case. So it's always important, if you're asking for a litigation funding order, to identify that the wife needs these funds to continue with her representation. A couple of other cases involved, one case, case of Wicks, 2009 decision. Wife wanted some money for litigation funding, and the question was whether or not the husband would have to sell a luxury car to provide that funding. Other orders had also been made for spousal maintenance and some sale of other items and application of those funds, but in relation to the interim property order, the litigation funding order, an order wasn't made because the court noted that the wife was in possession of a fairly expensive property, didn't want to sell it. She did have a modest nest egg available, and it wasn't appropriate in those circumstances to make a litigation funding order. And in a recent case of Wilson and Wilson, Justice Cronin refused to make an order where he considered costs that had been incurred to date were unnecessarily incurred, found that the solicitor had gone off on a tangent and incurred substantial costs unnecessarily, worked out that all that they were arguing about was a house and superannuation. It wasn't going to cost a lot of money to work out what was involved there. Didn't have any material before him as to what the real costs of the application were when the wife was asking for something like $30,000. Solicitor returns after lunch with an affidavit stating his future costs at 10 and counsels for 5 if the matter proceeded to trial. And Cronin J said, whilst the court was satisfied the wife had an inability to meet her ongoing litigation costs from her own income, assets and financial resources, there was no evidence as to whether her practitioner had any arrangement with her or not as to whether she'd be billed at the end of the case. And he struck out the application for lack of evidence. So have a look at the cases I've mentioned where cases have got up, cases have got up partially and failed. The last case I want to mention before we wrap up and take any questions or let you escape. Very important question of what happens if you're a solicitor acting for a party, party's got a litigation funding order, and then they leave you. How are you going to get paid? Do you wait for the trial and have to sue your client? Well, in one of those many Bing cases, a decision in February of 2009, and again by Justice Cronin, wife, if you might recall, Justice Mushin had made an order for litigation funding of $200,000. In that case, Justice Cronin, on an application by a solicitor, ordered that the former client, the wife, actually charge her interest in favour of her former solicitors to the extent of $200,000 in respect of her interest and entitlement in the property case, including any money due to the wife pursuant to an earlier litigation funding order. He also said, notwithstanding that the quantum of the charge of the sum ultimately due to the solicitors had to be determined either by the court or by agreement between the parties, he did provide a mechanism for solicitors to at least obtain security over costs when their client had left them for other pastures. I thank you for listening. I appreciate it was a bit rushed, but I invite you to have a look at the cases I've referred to in the paper, particularly those that failed, to see where people got it wrong. They're happy to take any questions or respond by email if there are any general inquiries parties want to pursue later. Thank you.